Thanks everyone for logging in. We are live. Always assume you're live. And we're just going to wait for a few more people to log in. We have a great webinar today. Darcy and I were just in Halifax for a conference, had a great time. And so we were talking about this webinar. We're really excited to do it again today. It's been a few weeks since we've done one. In 2 weeks, hosting a webinar with our HRC law team as well. And we have webinars planned every 2 weeks, all the way up until the holiday break. So we have lots of webinars coming, lots of free knowledge and ways to learn. And if you've noticed, we've really relied more on the Q&A, so you can ask any questions that you might have. Okay, so we're going to give it, we're at 100 people. Well, we'll start right away. So again, my name's Brett. I run partnerships here at HR Covered. I'm hosting the webinar today. And Darcy Michaud is our VP of HR, the brains behind the operation, for lack of a better term. And he's going to be talking about effective progressive discipline and termination today, which is a very relevant topic. And of course, if you have any questions, fire them away. I will get to them. Yeah, there's no bad questions. So ask any questions you want. I'm going to hand it over to Darcy now, and we will begin.
Sweet. Thanks for the intro, Brett. And hello, everyone. Brett, can you do me a favor and allow me to share my screen, and I will put up the presentation?
Okay. I don't actually know if I don't ever use Zoom anymore. Share screen. Advance. Is it going now?
I believe so.
Okay, there we go.
I think we're good there.
We're good.
Awesome. All right. So welcome everyone to it's more of a QA session. What we're going to do today is we're going to go through about 10, 12 minutes, I'm thinking, of just a slideshow. It's a condensed version of a presentation that I've done many times for clients and prospective clients. Effective progressive discipline and terminations in the workplace. Super important topic right now, just because there's so much uncertainty in the workplace, in the employment world. I have an old saying that uncertainty in employment means a lot of layoffs in a lot of nations. People would rather let go of people and bring them back than hold on to overhead that they're not necessarily sure if they're going to need or not. So a lot of people are getting out ahead of it. One of the webinars that we are planning to do this upcoming year is the difference between terminations and layoffs. A lot of confusion there. But for right now, we're going to stick to progressive discipline and terminations and jump through it. I talk quick, so I apologize in advance. This will be taped, so anybody who wants to come back and watch it, by all means. And again, you're going to see here that we do have the webinar online. At the conclusion of the webinar, we are going to be answering questions. So please start sending in your questions now. Anything you have. It doesn't even have to be on progressive discipline and terminations. If you have it, we'll do it. All right. So I'm just going to pause this for a second. What we're going to go through briefly again today: how to properly implement the progressive discipline process in the workplace, the different types of terminations and difference between each, financial obligations to terminate an employee, specifically common law, and then of course we're going to hit the live Q&A. All right. One of the things. Oh, by the way, I should premise this. I have a beagle. So anybody who's ever attended, because I know that a lot of you come regularly, you'll know that Tar Heel might speak up at some point during this. So if he does, I'll try to control him, but he's a beagle and he's loud. I can't help it. So key considerations about progressive discipline. Again, just a couple of slides. Not every infraction is worthy of discipline. So it's super important to know that when you're doing progressive discipline, that progressive discipline is for serious infractions. If you have an employee that's late here or there, by itself, that doesn't merit a progressive discipline. The last thing you want to do, and the reason why some progressive discipline processes fail, is because you water it down. Just like anything else, when you take minor violations and you tie a written warning to it, when you get to that point of termination for cause, and specifically willful misconduct in Ontario, the odds of you actually upholding that termination are going to be watered down, and thus it'll end up being a wrongful dismissal, and you'll end up having to pay a lot of money. So it's super important that you be tempered about how you use your progressive discipline process right out of the gate. The progressive discipline process is a specific path. So this is something that I would say most employers, and quite frankly, most HR people, are not really comfortable with as far as concept goes. What I mean by a specific path is there's 3 different paths that you look at from an HR point of view as far as process. There's progressive discipline, there's attendance, and then there's performance management. Performance management And attendance must start out as non-punitive in its nexus. If it starts out as a punitive process and you terminate somebody for employment for attendance issues or performance management issues, it will not hold up in a court. So it's really important that you recognize progressive discipline for what it is. It is completely disciplinary. There's coaching involved in the process, but every aspect of it, except for the first stage, which is the counseling stage, but still intended to be disciplined because there's a consequence there. It is a disciplinary process, unlike that of performance management and attendance management, which are both complicated and very effective processes in their own right, and a whole nother webinar for each. So the employer reserves the right and responsibility to discipline appropriately. So I always try to use the example that if you had, if you're a teacher in school and you had someone speaking out of class and they continue to speak up, and when the teacher was up there, you're gonna tell them maybe to go to the office. If you have somebody that comes up and hits another kid, you might suspend them. So if you have an employee who commits an infraction of, say, sexual harassment, for example, and you provide them with a written warning, you are going to end up in some hot water. And that's what this next point is too. If the Ministry of Labor, if you ever get a complaint, specifically when it comes to harassment, violence, things of that nature, there is a method for the employee to be able to go to the Ministry of Labor or Labor Board in any province or jurisdiction they're in. If the Ministry of Labor, they come in and they notice that for what would be a very serious infraction, you walked in and gave a very lenient, kind of discipline, if you will, if you were too low on the stages of discipline, not only will anything you did as far as upholding a termination in the end be threatened, but you could get a serious fine, because that's the same thing as condoning the action, is to take it too lightly. So these are super important things, high-end points that you have to understand about progressive discipline for you to have effective process in the workplace. But here's the big one: documentation. And this is straight up. I can tell you this stat. I read this stat about 2 years ago. I did a little bit of homework and I couldn't find a better updated stat. But in Canada, 80% of terminations for cause that followed the progressive discipline process failed. They did not uphold in a court or a tribunal. And over 90% in Ontario failed. And there's one predominant reason for it, and that's documentation. The documentation, it's simple, but it's super important. And this is what you must have in every letter of discipline. So typically in a progressive discipline process, you're going to have counseling, first written letter, second written discipline, so a suspension with or without pay, and then your termination. So every step of the way, you must have the cause of the discipline, the expectations and goals for improvement. You must have the level of discipline they're in, and what will happen if it, and this is the important part, the consequences for further discipline. So in other words, when you issue, say, for example, a first written warning, you should say, if this conduct or inappropriate behavior continues, you will be provided a second written warning or more severe discipline, up to and including termination with cause. It's super important. It's that last step, that if you do not have the consequences for true discipline in your letters of discipline at every single level, the odds of it holding up in court in Canada are nil to slim. The odds of it holding up in court in Ontario for when you have to reach the bar of willful misconduct is non-existent. And I'll explain that when we get to that, as we're coming up to it now. So types of terminations, and again, this will be a really quick slide because I'm being mindful that the Q&A portion, every time we do Q&A, it runs like well over the hour. Last time we had to cut it off at an hour, but we want to make sure we have time for that. That's the kind of the nexus of this presentation. So there's a probationary period. You're starting to see more courts and tribunals not recognize the probation period as it is in the Employment Standards Act or Code by itself, especially for executive employees. It's super important that the employment agreement includes a clause on probationary periods and your rights within them as an employer. Okay. Terminations without cause are by far the most common type of termination, and for good reason. Termination with cause can be more expensive than a termination without cause and are rarely successful. We still put it up there though, because it's one of the types of termination. And we're not going to discuss this today. In the presentation that we do more at length, there's other types of termination than the three up there, which most people are familiar with. There's constructive dismissal, which again, presentation all by itself. A non-disciplinary termination, very uncommon, but when you're going down the path of absenteeism, for example, if you have someone that misses a lot of time due to non-culpable absenteeism, like medical leaves, things of that nature, at the end of that process, you may have to terminate. It's almost kind of like a frustration of contract, but a different doctrine. And basically you're terminating them, but it's non-disciplinary. It seems kind of, contrary to one another, but it is a thing, and it happens very infrequently, but it's something to mention because that's what we're talking about. And then frustration of contract. Again, separate webinar entirely, very complicated doctrine, probably one of the most misunderstood by HR people and employers alike. What we're going to focus on right now is terminations without cause and with cause. Okay, so just a couple of really quick slides, and then we're going to hit the Q&A. So it's important to understand for those people that are either in Ontario or outside Ontario, but specifically for the people in Ontario, our bar in Ontario for what a termination is different than any other jurisdiction in Canada. Okay, so we have something called willful misconduct. In every single jurisdiction, in order to terminate somebody, you need just cause. Just cause, by the way, is when it's a serious employee misconduct where basically the employment arrangement has been irreparably harmed. It can no longer go on. That's every jurisdiction, right? Even Quebec, which is common law, just cause still, or it's not common law, begging your pardon, just cause is still the bar for which you need to terminate somebody. In Ontario, however, there's a different bar. So, and we're going to clarify the difference between common law and the ESA in a second. But Ontario, there's a different bar, and that bar is something called willful misconduct. So willful misconduct requires two things. One, it requires the act or series of acts to be egregious. So that's simple enough. It has to be something that's serious. Here's the tricky part. Whatever the act is, it has to be considered intentional or deliberate. In other words, there's a word for it in criminal law, mens rea or whatever, but it means that the employee has to be shown to be proven to be acting badly, right? So this is a perfect case that happened, a very recent case in 2022, Render versus whatever the elevator company is. I'm not even going to try to pronounce that. But basically what ended up happening was a 30-year employee and manager with the company. Basically it was a pretty loose atmosphere there, but put their hand, slapped the buttocks, for lack of a better word, I'm only saying that because it's a webinar, slash the buttocks of a female employee. So the employer, obviously just going through, like only a few months ago, a whole, sexual harassment, no tolerance kind of, training and policy, probably rightfully so in a lot of people's opinion, terminated the employee. In this case, the judge ruled at appeal that they had the right to terminate the employee, that even though we had 30 years and it was, no prior, because the courts will take past, the whole body of work into account, right? But because of the seriousness of the allegation, because they just went through this entire, no tolerance approach, that they had the right to terminate the employee for just cause, which satisfies the common law requirement, which we'll get into in a second. However, it did not meet the bar of willful misconduct. The judge ruled that and don't even get me started on this because I don't explain it. I can't justify it. It makes me laugh every time I say it out loud. But somehow that person slapping the butt of the girl, the female employee, didn't happen intentionally or deliberately. I don't know, maybe he did it through osmosis. I don't even get it. But that's the ruling. So in this case, what ended up happening was the employee was not able to seek any common law damages, which obviously was what they were seeking. However, the saving grace was they were able to collect the ESA standard, which in Canada or Ontario, begging your pardon, because we're a severanceable employer, which I'll explain later, it was quite a bit of money. So there's a difference between common law, which is the bar of willful misconduct in Ontario, which is the ESA bar in Ontario, and just cause, which is the bar all across Canada. And I'll go quicker. So why is this important with progressive discipline? Because we're trying to keep the trend here. Because progressive discipline, this is the clause where I said you must show the consequence of the action. What showing the consequence of the action does is it makes the failure to comply intentional or deliberate. If you continually tell an employee, this is what you're doing wrong, this is what you need to fix it, and if you don't do it, this is what's going to happen, and they continually do it, that's the bar, that's the proof that whatever that person's actions were intentionally deliberate. And that's the only way, and why that part of progressive discipline process is so important. That's the only way you're going to get a progressive discipline case to hold up in a court. Okay. And then the last thing, because it's only frustrating for me because I'm an HR guy. I've been doing this for like 30 years, right? It's not a game of horseshoes. You either have cause or you don't. I have employers all the time saying, I don't want to pay this. I'll terminate without cause because I get the liability of terminating with cause, but I don't want to pay them this much because I got all these things. And I want to sit down with the employee and tell him all the things he did wrong, but we're going to cut him a break and give him this much money. If you're terminating without cause, you're terminating without cause. You have no cause. There's nothing. You cannot use whatever you have against that employee that is negative and wants to make you fire them in an argument to lessen any type of termination obligation you have, which includes the right to common law. So I'm taking a look at the timer already at 15 minutes. So this will be quick. Common law, really quickly, you can terminate somebody in Canada as for whatever you want. Well, in a few jurisdictions, it's a little more complicated. For whatever you want, for whatever reason, as long as you don't violate the human rights, of course, as long as you pay them. Now, the problem with common law, what common law is that common law, I'm just going to throw this all up here and just speak to it in general, because it'll be easier and you can read it because I want to be mindful of time. Basically, what common law is, it's the theory of equity. So if you tell somebody that you've been working somewhere for 30 years, loyalty to an employee or loyalty to an employer, and they've been there for 30 years and they're a small company, so it's not a severanceable employee. So you say, listen, we're going to give you 8 weeks working notice. Thanks for your service, but 8 weeks is all we're entitled to pay under the Act or code. Here's the door, don't let it hit you on the way out. That's just not fair. And we know that's not fair. That's why we have common law in Canada, with the exception of Quebec, who has civil law. But that's why we have common law in Canada, which basically states, for just paraphrasing, you have to provide people, because you are unilaterally terminating the employment agreement, which is a contract. You are unilaterally terminating a contract. But because you are doing that, you have to provide enough money or time for that person to find similar employment in a similar geographic area, et cetera, et cetera, et cetera. So the things that the courts will look at is, we call them the Bardell factors, primarily is the years of service. The longer you've been there, the more common law you're going to have to pay. Age, even though age discrimination is illegal in Canada, it's against the Human Rights Code, the courts recognize that it happens. So the older the employee, if you're terminating somebody in their high 50s or 60s, it's going to cost you, because there's a lot of people that won't hire people, because even though it's not supposed to exist, it does. And then finally, the position and salary. If you're out there making $40,000 a year in today's job market, you can walk out the door, walk next door, and get a job. But if you're making $150,000 a year and you're a director or VP, that's a lot harder to find, right? There's just not as many jobs out there. So the last point, a well-mitigated termination clause in your employment agreement will definitely help. 15 minutes. I was trying to top it out at 12, but I got to the 15 minutes. Just indulge me for 1 second. I'll do this slide really quick as well. For those of you who have been on these presentations or are already a client, you know what we do. We're a full service HR firm, everything from compliance, health and safety, employee life cycle, HR strategy. We do consulting, recruitment, and legal, which I want to spend 1 minute on. We have a great promotion right now. Now, keep this in mind. What our HRC law team does is they're the only legal team in all of Canada that provides an unlimited legal service. It's an amazing product. So I always say to people, and I had a few people at the conference ask me this weekend, what sets your product like aside from others? Is I'm going, when you call that your HR expert, or in this case, the legal team, and it's like, okay, this is going to cost me $500. Is this issue worth $500? And then the next call, which is going to cost me $1,000, et cetera, et cetera. And the bill just keeps on going on. You don't have to make that decision now. If you have unlimited HR, but in this case, unlimited legal, you have a lawyer at your disposal, unlimited, as many times as you need, one cost, no retainer, no bills, just one cost for the year. So we have a promotion in place that we're actually starting, I think today or Monday, I believe, where you can actually sign up for a 15-minute free consultation with one of our employment lawyers, who are all spectacular. I strongly encourage you to take advantage of it, even because the 15-minute is free. See what it's about. They'll tell you a little bit more than I just did. And it's a great incentive. And I hope you all take the opportunity to use it. We will be sending out an email. Brett will probably talk about that a little bit later, but we will be sending out an email to that regard, for all the people that have registered. Thank you. Q&A. Oh, hold on. Yep, there's my dog. I always put a picture of my dog up on the webinar. He was quiet today, so thank you for that. But yeah, I'll stop sharing the screen and we'll get to the Q&A, and hopefully people have lots of questions. Happy to help.
That's great. Thanks, Darcy. So very informative. So lots of questions here. So I just want to ask one question that I have first before I get into the questions. When is it appropriate for a business to let someone go with cause? If it's so much easier to do it without, why would anyone ever do with cause?
There's certain things, and I'm one of the things, after doing this for a while, I try to, impress upon my clients. One of the things you really should try to do is keep principle out of any decision when it comes to termination. Termination is a business decision. It's nothing more. That said, There's certain standards. Workplace culture and workplace brand is so important. And there's certain standards that you have to uphold as a responsible organization. So when you get to things like breach of trust, which is what I terminate for cause, breach of trust is the number one thing. When you can't trust your employees, that's a problem, right? So, or you get to things like sexual harassment. Those types of things are the things that if they're condoned, that if your employees found out that you negotiated a package with someone who just went through an investigation and was determined to violate, the human rights of another human being, those are the kind of things that fester within a company. That's when the money and time that you would invest into a just for cause termination really merit. It's not, again, it's not a principle, but it's about, being a responsible employer and setting a clear example for your employees, if that helps.
That helps. Thank you. Okay, we have lots of questions here. I'm going to jump into the first one and take your time. We got lots of time here, 45 minutes. Okay, scenario. When you lose a contract and need to let one of your staff go, what paperwork is needed for this? Not discipline, I understand. So I think they're saying like they lose a business contract and so they've lost some business and they need to let an employee go. I believe I interpreted that correctly.
Yeah, that's what I'm
paperwork is needed.
Yeah, ironically enough, the termination process is rather simple. It's the process that leads up to that, trying to determine whether it's going to be for cause or not for cause, whether you can find another alternative and figuring out how much you're going to pay. The actual, that's more complicated. And that's, where you make or break things. The actual termination process is super simple. You're either giving what is the ESA or ESA minimum, which is a simple letter, basically saying, unfortunately, this is why we're letting you go. This is how much money you're owed. Give us your stuff back. We wish you the best of luck in your future endeavors. Or you're going to be giving them common law. And whenever you give additional money than more so than what you're actually required to provide, and this is a general rule, and I really urge everybody on this call to take heed, you never give anybody additional money without getting a full and final release signed in return. That's the give and take. So in that case, it's the same type of deal. It's the same letter, except there's an insert in there where it says, as well, in order to help you smooth your transition to future employment, we're willing to give you this much more money in exchange for a signed full and final release. Please take a week to review it, have it back to this person by this date. That's it. There's nothing more that needs to be done besides issuing the ROE. And then it's just wait to hear back, either hopefully from the employee with a signed release or from an employee with a counteroffer, and worst case scenario from an employment lawyer. 95%. I'm making this up, but I'm pretty sure that it's going to be around that area. 95% of cases where something goes to a termination and then there's a process, it just doesn't end right there, ends in negotiation. No lawyer, no client really, with the exception of a few that I've met in my time, no lawyer wants to take something to court. They can make their money and make good money just simply negotiating a contract to an end rather than having to, facilitate it in the courtroom.
Question. So someone signs a release, they get paid out, say twice what they were, had to by law. Is there any other risk for the employer that employee can come back and go after them again? Like when you sign a release, is that it? Or are there times when, like the person can say, well, I signed it under, like they forced me to. I'm just curious.
Yeah, the last point is actually one of the 2 or 3 things where there could be something go awry, and it's the most important part. I would imagine when I give an employee or a client's employee a separation letter and there's a release attached. If they told me right at that moment, listen, I'm just going to sign it. I want out of here. I don't want anything to do with you guys. It happens, right? I'm saying no. I'm going absolutely not. I can't accept this right now. You need to walk away. Come back to me tomorrow even. But you need to walk away of a sober second thought. Talk to somebody if you need to. You might even need to know when I do a termination, and this is a strategy. So this isn't a like a right or wrong thing. But if for anybody who wants to understand the logic behind why I do this, when I do a termination, I do not, because most of them are virtual, I do not give the employee the paperwork. I do the termination. I explain it to them. I give them the paperwork after via email or whatever it's going to be, or I give them a sealed envelope if it's in person and say, read that when you get home. Nobody makes a good decision when they're angry or upset or anything like that. So get them to walk away. It eliminates the duress argument. Make sure they have at least a day to consider, even if they don't want it, and that protects you in that way. The only other way, really, that you can get burnt there is if the release itself wasn't done properly. And that's the importance. Like I do know business people that are friends of mine that still do pull release documents and quasi legal documents. This is a legal document in this case. They pull the template offline. That's dangerous for obvious reasons. I could tell you right now that if you have an employment agreement with the termination clause and it hasn't been, and it's in Ontario specifically, and you haven't reviewed it in the last year and a half, it's not enforceable. I almost guarantee 95% of them are not enforceable. That's how much case law changes. It's forever moving. So it's important that, you keep these legal documents up to date via the companies or people that are able to do that for you.
Okay, got a good question here from Mary. Let's say you have not done proper documentation, okay, but you need to terminate someone and you do it without cause. What's the best way to go about doing it? Just and then it says like just pay more money that they're entitled to.
Yeah, like honestly, for me, a release is gold, right? I had someone, and they might be on this call, a matter of fact. I had someone email me this morning and say, listen, we have this employee, they're this year, this is how old they are, this is what they make, everything that they know to give me, because it's a client that I've worked with before, so they know what the information I need. And they said, do I have to pay this person common law? And I go, listen, you don't, but you always take that risk that, they'll ask for more, and there's a process to that. Me personally, this is what I would offer. I'd offer that little bit of extra money in exchange to get for that release. And then you can go to bed tonight and not have to worry about it. And that's really what it comes down to, because every time you terminate somebody and there's not a release attached, I guarantee you there's at least small, especially for smaller, medium-sized businesses, where a lawsuit or something like that could really be harmful to the business. That extra week or that extra 2 weeks of pay you're going to pay so you can get a good night's sleep. Every time you don't do that, you're going to go to bed and there's going to be at least a little voice in the back of your head. I hope I don't get the call from the lawyer tomorrow. Because as a rule, when you're in discussing terminations, you never want the employee to drive the bus. Whenever the employee drives the bus, in other words, whenever their lawyer initiates the negotiation, the outcome is always going to be more expensive. Period. It's a fact. It's what it is. So you always want to be reasonable out of the gate, maybe even a little bit generous, close it down from your end under your terms and walk away.
So the point of documentation, Darcy, is in the event that the employee does not sign a release, that you have a case on paper showing that you did everything possible or you documented everything. Is that correct or no?
Yeah, it's one of those things. Like if they don't sign a release, again, it goes back to when the term wrongful termination is so misunderstood. Wrongful termination, most people think that if you have a wrongful termination, that the employer did something bad or they were shady in their dealings or something. All wrongful termination is that the employee wants more money. They think they're entitled to more money, common law, right? And ultimately, the only person that can, with definitively, I have people tell me about these severance calculators online, and then they call me and say, "What's your difference? And why are you this much and that much?" And then they talk to a lawyer and they say it's this much. I go, ultimately, no one's going to be able to tell you for a fact what the common law amount is on any given termination. There's rules, like there's guidelines, the Bardell factors that we discussed in the presentation, but ultimately, it's going to be the judge kind of juggling or weighting of all the factors in each case, which will ultimately determine. So when they don't sign the release, they're coming back for more money. Again, all that documentation you have, you can't use anyways because you terminated without cause. It's not a consideration at all. So, when lawyers get together and even myself, when I negotiate with other HR experts or do negotiate with lawyers on occasion, when they get together, they will flip that out there and say, listen, we know this about your client and we get, let's try and be reasonable here. And some lawyers are more reasonable than not, or some HR people are more reasonable than not. I'm not always that most reasonable. So I have
next question
approach about it.
Can you comment on using progressive discipline when there's also a legitimate accommodation plan in place?
So I couldn't answer that question by itself, because I'm going to take a shot at it. What I'm thinking is that you have a person who's in an accommodation, so some type of work hardening, return to work hardening, what have you. And within that accommodation, they're not performing well. The answer is, as long as you can appreciate that the standards. So if you have somebody, I'm going to use widgets, right? If you have somebody that's producing 100 widgets and they have no accommodation and they're 100% healthy, safe, all that kind of stuff. And then you put somebody in accommodation and they're producing 80 widgets, but you're going to hold them to account for not producing 100, you're going to lose. So with an accommodation is basically a temporary employment arrangement. That's what it is. All accommodations are meant to be, for the most part, are meant to be short term. There are such things as permanent accommodations, but that's another webinar entirely. But within that confined, broken off employment arrangement, which is the accommodation, there also has to be a resetting of performance expectations and things like that. And it's a good idea. Like, it's a really good idea. I don't even use it as much as I should, but it's a really good idea that when you provide an accommodation to an employee, that you lay out the expectations for this period of time, right? These are what we expect you to do as far as duties. This is what we expect from you in the way of output. As long as it's outlined and it's reasonable from the onset, you can do progressive discipline, provided that the progressive discipline is based on tempered expectations.
Next question. Under attendance management, if I have a chronic offender, but they always provide a doctor's note, what are my options? I am based in Ontario, but under federal jurisdiction.
Okay, so first off, it's always wise to get appropriate medical, right? So, and I'm not gonna, I don't want to be condescending, but I'm gonna be. So I know like grade sixes that can write a note that says off work today for medical reasons. That's not, you are entitled as an employer, you are entitled to appropriate and satisfactory medical documentation, capabilities, restrictions, prognosis. That's what you're entitled to. So there's 2 steps to this, by the way. So you should be starting to ask for appropriate medical, and you can even write a note. And I did this yesterday for a client, where I write a note for them to give to the employee, to give to their doctor if they don't get the permission to speak to the doctor, directly, basically saying this person has missed this many days over this period of time. You have provided the medical. Is there a medical issue without providing a diagnosis that requires this person to be visiting you so often? And then if you get that, then obviously you can start to work on accommodation, because you can accommodate around chronic absenteeism. For example, if someone, and this is the second part of it, if you have somebody where you could say, listen, you have missed like 5 days a month for the last month, try and find what you do is you try and find like the trends where it's happening, if it's happening in the mornings, Friday afternoons, what have you, and said, so if we can't, work this out and you have to see a doctor, you're going to be sick that much, we're going to start to accommodate you to a part-time schedule where, you work if 5 days is, 25% of it, we're going to accommodate you to a 75%, so you can start to feel better, because clearly what's happening right now is not working. So there's ways to get around that you're kind of manipulating. You're not manipulating, you're respecting the human rights code, but you're also taking the other aspect of the human rights code, which is your obligation to accommodate, and using that as a tool for something that person would have a protection against under the same code. But get the appropriate medical first. You can't do anything without appropriate medical. Stop accepting doctor's notes that say off work for a week for medical reasons. Not appropriate.
All right, good answer. Next question. What would you determine as to be a small period of time for excessive tardiness? Our organization has a mix of casual, part-time, and full-time employees, so it's hard to have the same threshold for all.
Yeah, it's typically, so just so you know, I mentioned in the presentation about attendance management process. Attendance management processes are incredibly complicated if done properly. So they take time, but they do have an outcome where you can actually terminate somebody, even if it's non-culpable absenteeism. In other words, it's legit sick time, or it's a legit illness or something or the other. At the end of that process, you can actually terminate somebody and not cost you anything, right? And the employee has an obligation, to work with you on that. But at the end of the day, the rule for any attendance management process is you take what the average amount of days is per year for the industry or sector. And typically you're around 7. And then you either go, depending on how lean you want to be, you times it by 1.5 or 2. So you would be looking at 10 to 15 days per year would be considered the point where that would merit you entrance into attendance management program. Even though I'm not a fan of using attendance in a progressive discipline, that would merit you entrance into a progressive discipline process. Just make sure that if you do that, that you're providing support, that you're actually fulfilling your duty to inquire. Make sure that they don't have a medical issue that you're unaware of without asking them to disclose a diagnosis, and offer your support if they do, right? As far as the casual piece, part-time piece, full-time piece, prorate. It's that simple. So if you have somebody that works 50% of the time, then, I would say double it up. So 7 days, double it up, say 15 days, which is doubling up and a little bit more, and say, okay, what's appropriate for you to miss over the course of the year when you're only working half time? 7 days. There's really no right or wrong there. You can establish your own standards. Just keep it in mind, the greater the standard, the more likely you'll be able to hold a just for cause termination if that's the path you go.
Okay, next question. Just cause question 2. Would performance issues after several verbal warnings and written warnings with an improvement plan and no cooperation, would this be would you be able to use this as just for cause?
Yeah, that's, keep it in mind, like at the end of the day, I'll preach, I'll stand up here and yell at the top, and most people will that have been doing this for a while. They'll say going after a just for cause termination is folly, right? Like a lot of companies, like I'm a hire fast, slow person, fire fast. When there's a red flag, I just pay the money. You're done, right? But the progressive discipline process was made for a particular reason. It's exactly for what this person's client or this client's question was, is if you do the progressive discipline process properly, yes, at the end of it, you should be able to terminate for cause. Even in Ontario, where the bar of willful misconduct is there, as long as it's seen that, again, you're documenting accordingly, you're making them well aware, specifically aware of what they're doing wrong, you're offering support, right? That's super important to get a for cause termination. And then there's a consequence. Because they know what the consequence is, you've offered support, they know what they're doing wrong, and they know what they need to do to improve. If they consistently don't do it, and there's enough period of time in between the steps, so it's not like here's a discipline today, here's a discipline tomorrow. There's got to be time for improvement, right? As long as there's all those things present, it is possible to get a successful termination for cause, even with willful misconduct in Ontario.
Okay, next question. Is there a change in a manager and the employee out of right says that they do not do anything the manager asks for them and continues to not work with the manager? Is that just cause? Are they working, but they are bypassing their manager all the time?
Yeah, it's a little confusing.
I think saying that if the manager is saying things and the person's not doing what the manager is asking and avoiding the manager, cannot be a situation for just cause. And I guess it would be if there's proper documentation in place and you do it over time. Otherwise,
exactly. It's a nexus to enter the progressive discipline process. I would suggest it's insubordination. It could be flat. You could call it insubordination. You could say failure to adhere to your employment terms, what have you. But whatever you want to call it, it definitely is a nexus to enter in a progressive discipline. Typically, quite honestly, most progressive discipline processes, if it's a well-intended employee, end at the first written warning. When people see stuff in writing, it changes their whole perspective on things. And that's just human nature, right? So if you get somebody that gets to the second written warning, and I hate to be jaded, I've seen a lot of stuff over my years, but if you get somebody that gets to the second written warning, there's a better than average chance they're gone, right? They're not coming back. That's when you have to make the decision. Do I want to continue through with this and go through this grief, or do I just want to let go of this person right now? But yes, to your question, I think I answered it already. I think. I don't know. I went on my tangent again, down my rabbit hole.
That person can always post the question again.
It is a nexus to go into the progressive discipline process.
All right. Okay, next question. If we notice an employee who has a performance issue, is it worth to extend the probation period, even though he or she already enrolled in the benefits program?
Okay, so that's a really good question, because I keep on getting this and I don't know why. So it's maybe this is a client who's already asked this question, I'm not sure. As long as people understand, the term probationary period is not an ESA or ESC term. It doesn't exist in legislation. That is something that employers have made up to match the piece of the legislation that says after this period of time, you now owe this person termination pay. Employers tack the term probationary period on it, right? Because it makes sense, you're in probation. So as long as you understand that extending the probationary period, you could have a probationary period for a year, like right out of the gate. You could extend it 5 times, what have you. It's an employer management tool. It's a way to say to the employee that you're not where we need you to be yet. We're going to extend your probation and keep you in the evaluation period. Make no mistake, though, you cannot extend the ESA or ESC, what would be referred to as probation period. So, for example, in Ontario, it's 90 days. In British Columbia, it's 90 days or 3 months, one or the other. At that period of time, even if you extend probation and you terminate a month later, you still owe them termination pay, period. So it's a management tool. You can't contract out you can't contract out the legislative rights of the employee. But I will say the other, fiduciary benefit of extending the probationary period is it does, at least in theory, I actually don't know practically if this holds true, but in theory, because you're still in an evaluation period, you could argue that that lessens their entitlement to common law, because again, it's known to both parties that they're in probation. I don't know. That's a theory that I've heard a couple of times. So you hear a couple of times, you think it might be true, but I haven't seen it tested and tried. But as long as you understand the difference between probationary period and what's actually in the ESAAC, you're cool.
Next question. Is suspension without pay considered constructive dismissal?
It is if you don't have a policy or something in the employment agreement. So if you don't have it, like, first off, if you don't have a progressive discipline policy, your progressive discipline process isn't going to hold up anyways, period. Because the employee couldn't possibly, you can't prove, especially in Ontario where you require willful misconduct, you can't prove willful misconduct when there's no resource for this person to follow. So it should be in your policy. Interesting fact, your policy should be provided to the employee at the time of signing the employment agreement, and your employment agreement should always be signed before they start work. Once an employee steps foot into the workplace, they're legally not required to sign an agreement. They're hired, but they're legally not required to sign an agreement. But the policy manual should always be provided along with the employment agreement at hire. I've actually got a workaround in it in my employment, one of my employment agreements that I developed, where I said that you will be presented with the policy manual within 14 days. You must review it. If you have any questions, ask, and then get them to sign an acknowledgement form. In that policy manual that's referenced in their employment agreement, you'll have the space there, the progressive discipline policy, that says this stage is termination without cause. So they're agreeing to that stipulation in advance. The other factor there is when you suspend somebody without pay, you suspend them for a day. You maybe suspend them for 3 days, but suspending for more, the idea is not to punish. That's not the point of a suspension without pay. The idea is to drive the point home. You're getting suspended without pay for a day. Next time you're gone, right? That's all you're trying to do, is emphasize the point. You're not trying to punish, which actually mitigates a 1-day suspension mitigates most any claim of constructive dismissal.
The next question is from beautiful British Columbia. So that's our context. If you are doing written progressive discipline, you write 3 written warnings, all about different performance issues that are not exactly related. Can you still terminate with cause?
You're going to have a hard time. So, there's something, and I actually don't know if this is a term in HR. I had an employment lawyer that I worked with when I was working in municipal government, and he always referred to it as umbrella discipline. And basically you said, if you look at it, if you have an umbrella and it goes like this, right? You have all these different disciplines like policy infringement, attendance, perform, whatever it is, and it all falls under the umbrella. But whenever you're trying to look at a case for the idea that you've caused irreparable harm to the relationship, or you're trying to say this person reached the bar of willful misconduct, which is not a thing in Ontario or BC, but it usually should have some type of path upward. It's progressive. So I like to stack a little bit. So when you get something where you have a discipline for one thing, and then you have another discipline for others, I would give that, I would make them both first written disciplines. And then on the second written discipline, because there's a couple of infractions, you could say due to the frequency of your infractions, or due to the multiple infractions, your next written warning for any infraction would be in fact a second written warning. And then again, if they're different things, you might want to give 2 written warnings at the second level stage. You might give 2 written warnings at the second level stage, so on and so on. The more you do in a progressive discipline process, the more you will have a chance of holding a for-cause termination in the end.
Excellent. Thanks, Darcy. Next question. We see many employment contracts have termination clauses limiting entitlement for without cause terminations. How do those termination clauses impact common law entitlements when terminating without cause? Are there limitations to the termination clauses?
Yeah, that's a big question and a long answer. So that would be like, we did the condensed 15-minute version. I spent like a half hour talking about that, right? So because there's a lot to consider, especially over the last couple of years with the case law that's come out. So like typically, what to start this off, because this is important for everyone to know, courts in Canada, and they've made no bones about it. They've literally come right out and said it, like actually said the words, we do not like restrictive covenants. A restrictive covenant is anything that restricts the rights of the employee, non-solicits, non-competitions, trust termination. It restricts the rights of employees. We do not like restrictive, and why? Because restrictive covenants fly in the face of common law, period. So technically, and this is what it comes down to, if the clause is well written, then yes, but well written requires a lot of things. It requires that the employer is portraying to the employee, and the employee should have a necessary understanding of what it is that they're giving up. So they have to clearly say, so for example, in those provinces where you have to extend benefits through the notice period, you would clearly need to say that you will be terminated with this much notice as per the ESA, ASC, and you're, as well as any other compensation owing to you in the notice period, not up to including, and there's wording that I use, but including benefits, bonus, commission, et cetera, et cetera. If you don't put that line in there, like any of those lines saying that they're entitled to these things through the notice period, then your clause will be deemed void. If your termination clause, there was recently a case law that said you have to look at the termination clause as a whole. So what happened in this case, and it's important for everyone, this is actually worth the time to talk about. What happened in that case was there was an employer that terminated somebody without cause and said, we owe you the ESA minimum or ESA minimum. I forget which jurisdiction it was in. And the judge agreed that the what do you call it? The actual not for cause termination clause was solid and enforceable. But then they looked at the for cause termination clause and said that wasn't enforceable. And because the termination clause must be viewed as a whole, then if you screw up in one aspect of it, even though it's not the part of the clause that you're using, the other aspect of it is unenforceable as well. So there's a lot there. I tell people that, and I know this sounds awful, but whenever you get a termination clause, and it's what it is, employment lawyers and HR experts can do their best. We can do their best, but I guarantee you 2 years ago, there was a lot of HR experts and employer lawyers who thought they gave a ironclad termination clause to their clients, right? And then 2 years later, there's been 2 cases which have made almost all of those termination cases void. You do your best with the case law at the time, right? So right now, it's always wise to have your termination clause reviewed on an annual basis. And if it's written properly, it should uphold a termination not for cause for ESA only.
Okay, we have lots of questions to still get through. All
right. The list keeps on getting bigger.
Here's a good one. Okay. If we have a pregnant employee and they inform their supervisor that they're moving to another city and they are leaving the organization permanently, but they submitted their request to HR for a maternity leave with a return date, can we terminate this employee or ask them for a resignation during the leave as we need to replace with permanent employee?
I totally don't get that because I get it, but it doesn't make sense. Do you know what I mean? So
like the employee, it's bad. It's a bad play on the employee side of it. So they've said, I'm pregnant. I plan on leaving. I'm not coming back, but they haven't resigned actually, but I want to get my maternity leave because I'm moving to another city.
So the employer just needs to call the employee and say, can you please submit your resignation date effective the end of your maternity leave, which is basically them giving them working notice, which gives the employer the right to go out and seek a replacement. It's that simple. The employee is trying to be smart, and they are, and I get it, but it's just a lack of understanding about what they have the right to do. The employer just has to turn around and say, just listen, we know what you want. We want you to have your maternity leave. We want you to have your maternity leave. Just submit your resignation effective the end of the maternity leave. We'll consider it. We'll accept the notice. And then you can continue on with your benefits. You can continue on your maternity leave. We can go out and find somebody else to replace you. Leaves things amicably.
What about the matter of a layoff due to lack of work? I know that's, the layoff story, but.
Yeah. This is a misnomer. Now, I know you're going to see it in a lot of literature, and we are going to do a webinar on this, so I'll be relatively quick. You'll see the term permanent layoff in a lot of literature. It's really a made-up word. I think the Ministry of Labour and Service Canada have kind of adopted because they don't want to try and explain it. But at the end of the day, there's only a temporary layoff. A permanent layoff is a termination. So if you're doing a permanent layoff, there's nothing wrong with doing that. But the intention is that you have to bring them back. It's different for every jurisdiction, but Ontario I'll use it as an example because it's right off the tip of my tongue. After 13 consecutive weeks of being on a layoff, you have to terminate. Well, they're terminated. Like if you try to call them back on the 13th week plus 1 day, they're already terminated. You owe them termination pay. So that's automatically. So, a temporary layoff is just putting off, either you have an intention to get them back or if you don't within 13 weeks, then you owe them the termination pay. The termination pay is going to be the same calculation as if it was if you did it from day one. So if you know you're going to do it, unless you're putting out the obligation to pay termination pay, do it right away.
All right, next question. If we plan to terminate someone due to their performance, can we post their position online looking for a new candidate? And what happens if that employee finds out? How do we explain that to the employee?
Well, you can't. That's if the employee claims constructive dismissal because you're doing irreparable damage to his reputation. Well, you're doing damage to his reputation within the, you're looking for his replacement while he's still there. If he claims constructive dismissal, he's likely going to win. So you'd end up having to pay him well more than just terminating the person and go and look for somebody.
Okay.
Not saying that employers don't do it all the time though. So
next question. In the social work field, if you are trying to make staff feel safe in a challenging and anxiety-filled field, how do you avoid making them feel unsafe if you have to deal with issues that are disciplinary issues with a verbal or written warning?
can you say that one more time? I think I got it, but I just want to make sure.
Okay, in the social work field, if you are trying to make staff feel safe in a challenging and anxiety-filled field, how do you avoid making them feel unsafe if you have to deal with issues that are disciplinary issues with a verbal or written warning?
Yeah, I don't get it.
Okay. I have another question here from someone who's anonymous, and I don't quite get it. I apologize. I'm going to have to dismiss that. We have 20 left. Okay. Terminations are easier when the employment relationship is below 5 years at least. But what are the points to consider when the employee has been working for 35 years? You kind of touched on that earlier, but explain.
Yeah, it's the employee working for 35 years. You could almost knock it out of the park. It's not a hard cap, but it's traditionally been a hard cap. And unless there's exceptional circumstances, 2 years is the maximum that you have to pay in either working notice or pay in lieu of notice. So someone at 35 years, unless they're like a really low level paying employee, but at 35 years they're probably at least in their 50s. They're probably in a better position than what they started, and of course they've been there for 35 years. It's going to cost you a couple of years to get rid of them.
Okay, so they want to terminate someone due to a performance reason. How do you best communicate that to an employee that we're going to terminate you?
So just not for cause, just getting rid of them. We take a look at our future requirements and we just don't see this as a fit going forward. Classic HR rule. And I'm telling you right now, it's the hardest thing in the world to do when you actually have to do it. When you're terminating not for cause, never tell them the reason. You are allowed to terminate not for cause as long as you pay them, period. Don't tell them the reason. As soon as you say anything, as soon as you give them a reason, oh, we're terminating you for performance, but we have the right to do that, so here's your money. Then you get the call from the lawyer that said you didn't have a performance management system in place, you didn't adequately support him, blah, 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 blah. You don't have to give the reason, and you shouldn't. It should always be, we've looked at our future requirements and we just don't see this as a good fit for either party going forward. That's it. The employee will sit across from you. They'll be angry. They'll be sad. They'll be screaming. They'll want to know, why are you terminating me? We've looked at our future. I know it sounds cruel, and it is to a certain extent, but this is a business decision. You never give a reason for termination for cause. You pay your money, you walk away. That's it.
And Darcy, to add to that, it should always be two people like in the room, like ideally an HR person and someone else. But like, can it be virtual on a video? Can it be on the phone? Can it be in person? Or what can it not be?
Yeah, ideally you should always have two people in the room. It doesn't always work out that way, but this is more of a business acumen thing than anything else. You kind of go through the most personal ways of terminating. So obviously in person, virtual, over the phone, written letter, like that kind of scale. That's the first one I mentioned. In reality, if I have the choice to terminate somebody in person versus virtually works, because you have this. Right? You have the recording, you can tape it, you can ask for permission to tape it, but there's something to be said for doing it virtually. In a virtual organization, it's easy. And if it's one of your, like for me as an HR guy doing this for clients, the virtual thing is easy. For me doing this for my own employees, however, and this just goes back to trying to be a good person, trying to be a good HR person, employer. Obviously, if I have the choice, I'm going to do it in person, and there's going to be a second person there. The only one thing you can't do is bring in someone at a lesser level than the person that is getting terminated. Sometimes you see it in the way of someone coming in to take notes that's at a lesser level, but unless that's their job, like unless they're an executive assistant or administrative assistant, and that's what they do anyways, it's inappropriate to bring in somebody at a lesser level to be the second person in a, or even at the same level, to be a witness in a termination.
Okay, great. We answered 3 questions in that in your reply there. So hopefully when
Awesome.
questions that we hit. Next question. Can you explain common law as it pertains to Alberta? As in, is it different in Alberta than say in British Columbia or Ontario?
Nope. The only place where it's different is Quebec. Now, it doesn't mean judges in each jurisdiction don't treat it differently, right? Because it's the rules stay the same, like the Bardell factors are the same, but Alberta is by far the most employer friendly province. So it wouldn't surprise me if a judge in Alberta would give 50% of what a judge in BC would give for common law. It wouldn't surprise me. It's not supposed to happen that way because you're supposed to work on precedent, but that's just the way it is. But technically it's all the same for every place except Quebec.
Next question. If an employee gets terminated without cause and they are not happy with the severance amount that they are being negotiated, can they negotiate more money?
Yep, all the time. More than like 80% of the time, you give somebody a term. Like, it's a scary prospect for employers. If you're okay with just the fact that just treat it this way, people call it a negotiation. All it is a back and forth. They want a little bit more money. You either can or you can't. If you can and you want to meet them halfway, then meet them halfway. Both parties are happy, you move on. But it's a more intimidating process. It's a less intimidating process than what you would think.
When is it appropriate to actually ask for a medical note if you're the employer?
That's a loaded question. Like a loaded question, because there's about 500 times when it's appropriate and there's about 100 times when it's not. But typically, as a rule, if you see a lot of people that say after 3 days, we're going to ask for a medical note, I'm not a fan. I think that we have to have some respect for our medical system in Canada, and the idea that if you have the flu, you're going to be out for 4 to 5 days, and we know that. So asking for, I think you can say we can ask for a medical note between 3 and 5 days. And if someone tells you they have the flu and, there's no reason not to believe them, say, okay, well, if you're gone more than a week, give us a medical note. But certainly anytime anyone discloses a disability, discloses that they might go on have a long-term illness or anything of that nature, you go out and you get a functional abilities form, prognosis, restrictions, diet, and capabilities. It's super important.
Excellent. Okay. So we have 2 minutes left. Darcy, how much extra time do you have? I know you got a lot, like you're always busy.
I can cancel my next half hour. I was on a meeting till like 2 minutes before this webinar came on. They were Sony and Brett were like giving me hell because I was like 2 minutes early. I go, hey, I'm early. Like,
yeah. You were early. Yeah. No, just keep getting rid of the questions and they keep coming back, which is great. It shows that lots of people have questions. And keep in mind, in 2 weeks, we are doing 2 weeks in a row. Actually, we're doing webinars. Ask Me Anything with our employment lawyers, so you can ask questions then. But let's keep going then until you say you got to go. We have an employee. Okay, here's the question. We have an employee who we are planning to terminate. They entered the profit sharing program on August 20th. There is no formal agreement for this, and typically payment is only made if they are employed on date of payment. Should we still pay out their accrued portion?
It depends what your employment agreement says. And this is where, this is something that when you get into the conversation, I do a webinar on it. But certainly when you get in the conversation with our legal team in the next webinar, as Brett said, this is something, the employment agreement is by far the most important document in the life cycle of an employee. That all needs to be laid out in the employment agreement in advance. And if it's not laid out properly in the employment agreement in advance, you're going to have to pay it more than likely.
So it's probably safer just pay it
You can do it on a prorated basis. You know what I mean?
Yeah.
Like, you could do it on a prorated basis. If it's going to be a yearly bonus, I would first try, because nothing's in writing, I would first try to give it to them on the prorated basis of whatever they've been there for the portion of the year that the eligibility period for the bonus was, and see if that flies. Right. And I think you would have a strong, there's good logic behind it. So I think you'd have a strong stance on that, especially if the other person's reasonable.
Okay. During progressive discipline, if an employee refuses to sign any performance improvement plans, warning letters, or any documentation, How can we prove that they are aware and have received these warnings?
Did you give it to him? Like, honestly, I apologize to everyone in advance. This is a pet peeve of mine. Discipline is not, it's not a discussion, right? Performance management, I got it. You sit down with someone, you have a performance management meeting, you discuss it back and forth, you do something that's collaborative and meaningful with a goal to move forward. And so both parties should sign signifying their agreement to move forward. And that's good. And I like that. Same with attendance management. Discipline ain't that. Discipline is the dad yelling at the kid or the mom yelling at the kid or whatever it is. This is not a two-way street. You did something wrong. You know you did something wrong. We're telling you what you did wrong, and here's your discipline. I don't want to give that person the opportunity to think for even a second that somehow them not signing that paper means that they don't agree with it, so they don't have to take it to heart. So that's just my opinion. I know there's HR people out there that wholeheartedly disagree with me. I'm like, hell no. It's like, I'm giving you, if I've got to the point, because I do not discipline easy. I give people a lot of chances and I work with them. If I get to the point where I have to discipline something, they know it's coming and I'm not giving them any idea or giving them any indication that somehow this is a two-way street. You screwed up, here's your discipline. Don't do it again.
Okay, a quick one here. This is all new to me. Is your advice in general terms, termination without cause and pay appropriately? So it, like, in general, terminate without cause and pay them more than they should probably get, and then get them to sign.
You don't even have to pay. Yeah, you don't even have to pay them more than they would have apparently get. You just have to pay them what they would, like, what would they get in a court, and scale some of that back, because they're not going to court, so they're saving money. But whoever the person that is new to them is, the way they said that in general is spot on. Spot on. Couldn't say it better.
Okay, so they have an employee, they have stress problems, anxiety, panic attacks. They just take off from work. They take days off. It's having an impact on everyone else. They've done their best efforts to provide support and accommodations. How do they actually terminate them?
Okay, just a heads up. My one kid's coming home. My dog's going to freak out in a second. So I just letting you know. So can you read the question again? I'm sorry.
I just dismissed it, but so yeah, they, someone has anxiety, they're having problems with them, they're showing up, they're taking off early, they're not showing up, but now they want to get rid of them. Like, the employer's like, let's get rid of this person. What's the best way to get rid of them? Without cause?
Well, yeah, you can't get rid of them for that. You can, but you'd be opening yourself up to a can full of liability. You need to manage the employee. So managing the employee first starts with going out and getting appropriate. That's exactly the time. That's exactly what a functional abilities form is meant for, to go out. And if anybody needs one, we've given them out before. We can certainly send them out to all the people that have participated in this process or this webinar. But you need to figure out what's going on, because if you terminate that employee, full well knowing that they have attendance issues that you could tack to, which could be an illness or a disability, the human right, the one place you never want to end up. You end up in a courtroom. That's one thing. You end up in a human rights tribunal, you could be talking six figures. You do not want to end up there, and that's exactly where you may end up if you terminate that person.
I understand that employers are within their rights to restrict common law notice by paying notice/pay by indicting that for any termination, they will only pay the required amount in line with the ESA. Do you know of any cases that have changed this in a court of law? I'm thinking from the perspective of a long-serving and possibly older employee.
Yeah, it's basically the two cases. The one I mentioned in the actual presentation, these are the two most recent, and it's not so much that it's been changed. It's more so it's the validity of the termination clauses themselves. If your termination clause is ironclad, which, by the way, there's no such thing, because the courts have proven that they will look at every possible factor to try and find a hole in the armor, if you will, then you're fine. And there's no case law that I'm aware of that suggests otherwise.
Can you dismiss an employee who's off on short term due to addiction issues, but not compliant to treatment and doesn't respond to calls from the employer or the benefit administrator?
You can, but it's not that simple. So, at that point, it's a case of you would likely want to be going through the job abandonment process. So this is another thing. If it doesn't, I'll try and answer another question at the same time. People that say this person is assumed to resign and all this different kinds of things, which is similar to what this person's saying, but not really. Employees can't be assumed to resign. they either resign or you terminate them. In a case like this, it would be a case where you would reach out to them formally, 3 steps, not unlike progressive discipline, explain to them that you have an obligation to do this, you have an obligation to communicate, you have this much time to get back to me, or, what have you. If not, we will, go down further down the job abandonment process. The second letter is same thing. You are now in the job abandonment process. If you don't respond by this date, you will be terminated with cause down that road. And then when you do the termination with cause, you put a caveat at the end of the termination that says, should you decide to participate or come up with a good reason why you haven't participated to date, we may consider your employment status. That protects you against a human rights claim.
Okay, I'm going to try and shorten this question. So basically, if you add policies into place, you did not have them before, you add them into place, do you need to get your employees to sign them, or can you just email it out to everyone and say, okay, this is our new policy?
It's a good question. It depends on the policy. So if it's a policy that impacts the meaningful terms of employment, then you're not only going to need to get them to send it out and sign it, you might have to give consideration. In other words, if you're changing their employment terms via a policy route, you might have to give them something of value because you're amending their original contract terms. And if you don't, that could be construed as constructive dismissal. If they're policies that are operational only and they don't meaningfully impact the employment terms, they can affect the employment relationship and not the terms, then yes, you could just, put it out there. It's wise to give them notice that this will take effect in, 2 weeks, 4 weeks, 8 weeks, what have you, but you can just put it out there, but it does depend on the policy.
Why is it easier to terminate someone within the probation period rather than someone who is past the probation period?
Simply because you have to, 2 reasons. One, if it's within that period of time, which the ESA or ESA mandates that you do not have to pay termination pay, then that's the first reason, is it doesn't cost you anything. But the second reason is you could simply say, you're still within your probationary period as per the employment agreement and the employment legislation. We deemed it, we're just going to part ways. So it's, you actually have a reason, but you're not giving a reason. You're just pointing out to the employment agreement or the ESA, and it doesn't cost you anything.
I'm going to shorten this question too. You've terminated someone, they've been paid out, but they have the company laptop still. How do you get the company laptop back?
You got to take it to court. I get all the time. All the time. I get that question all the time. It's the only thing you can do. Take in the small claims court, pay the money, and get it back if it's worth that much to you.
Okay, employee on a medical leave of absence that stops communicating, does not answer calls, emails, or texts. Date has passed from the last medical note for return to work. Now what?
Job abandonment process. Just as we discussed a couple questions earlier, reach out to them. You are required to provide us with this documentation by this time. If you don't, you'll be entered in the job abandonment process. Go through the 3 steps, follow up with termination with the little caveat on the termination letter.
And the person that asked before about trying to hire someone who they want to fire, but they haven't fired yet. Like, what if we call it a different, position? So instead of an office secretary, we're hiring an office administrator.
It's fine. It's like I said, clients do it, most of the clients, but I know a lot of employers do it all the time. It's if the employee finds out, it's constructive. It's what risk do you want to take? If you're averse to risk, then give it a shot. If you're nervous at all that this person's going to find out or someone's going to tell him, then that's the liability you incur.
A good one. So someone's been terminated, but they were really close with all the employees. What can you do as a business leader to really kind of calm everyone down and bring everyone back together? You
just have to be transparent. You can't say the reason why the person was terminated, but you really should get everybody in a room and say, listen, and acknowledge it. I'm telling you, whenever I've done facilitation, whenever I've done mediations or any type of, I've done a lot, worked with the unions for a long time. So I've done a lot of labor relations. The best way to deal with something which is a sensitive or angry issue for employees is acknowledge what it is that they're angry about. Get in front of your employees and say, listen, I understand that this person was a friend of all of yours, and I am truly sorry. This is not something we wanted to do. Get in front of what you did, why it's important to your employees, be empathetic, and then bring it back to, this is something we had to do. We want to be here for all of you. You should know, none of you should be worried about your job. Obviously, there's reasons why we can't disclose the reasons why we had to separate, but we want you to know we wouldn't do anything unless it was absolutely essential for the betterment of the organization and everyone else here. Something like that.
Perfect. Next question. They've been working with an individual on a performance improvement plan. They obviously know that it's due to performance. Do they need to tell them why? I would assume no. So we don't tell them what the performance issue is?
Oh, if they're terminating?
No, I don't think it, well, it doesn't say terminating. I think it's just trying to improve them,
Oh, then you have to.
right?
It's
Because otherwise, how would you know?
Yeah, no, it's the same thing with progressive discipline. Any process, you have to understand, HR doesn't work unless it's transparent. If you're trying to slip through something through an HR process without transparency, when you get to the end of the process, you're going to like, just let me say this, Brett, because I know we got questions, but this is important. When you go through any of these processes, you will never get taken to task during the process. You get someone a written discipline, they're not going to go to their lawyer and take you to court because you're allowed to discipline. Right? When you do something in performance management, they're not going to, you're allowed to performance management. It's only when you get to the end thing, which is typically the termination. And that's when a judge, a tribunal, a ministry inspector, whomever, then they go back and look at everything you did. So you will not be taken to task for anything you do until the very end when it's too late. You either did it right or you did it wrong. So it's super important that you're transparent around the entire process, because if the third party at the end of it can't see exactly what you did and why you did it and how you did it, then you will not win in a court, period.
This is a great question. And I used to do recruiting at HR Covered, so this is very relevant. You get rid of somebody without cause, and they were problematic, but you just said, we're just going to get rid of you, right? But then they want to use you for a job reference. And then the future employer reaches out. Can you be honest, or what can you say and what can you not say? Or you just decline it?
Yeah, you can decline. Two, you could say, and this is what I recommend, say it is our policy that we only give employment references. So I can tell you that this person started on this date, this is the job they did, and this is why they were let go. Not for cause, like just not a good fit. And that's it. Because anything that you provide is subjective, and they don't get a job because you provided something that was subjective. In other words, your opinion could lead to them not getting that job, which is a potential loss of earnings, which could be the rise for a civil suit.
Does it change without cause in a unionized environment? Like, can an employee?
There's no such thing.
No?
Okay. No, not unless it's negotiated with the union.
Okay. Can we get a recording of the session? Yes, you can. And it's on, I believe we send it out to everyone after, and you can always contact us if you don't get it, but you should get it. But we record everything. Okay, almost done here, Darcy. And if we don't answer all the questions, again, we are doing a legal one in 2 weeks, and we will get back to your answers regardless. How can we prove that employees are aware and receive the warnings during progressive discipline if employees refusing signing any performance improvement plans, warning letters, or documentations? Are you kind of asking?
You could put a thing at the bottom said this signature is only represents a acknowledgement that you received a letter, and if they don't sign it, then you just write employer refused to sign the letter, give a date, give a copy to the employee, and say there. But never, if you're going to use a signature, which I'm not a fan of, make sure it specifically says this is only to acknowledge that you received this letter. That's it. You're the employer, they're the employee.
Well, we still have 99 people on here. Incredible. Thanks for hanging in there, everyone. We're trying to get through this. Okay, you have an employee who misses like 5 to 10 days a month because the migraines. It's a receptionist. They had a doctor's note. The doctor said she's on a new medication and should be better. But she's still not around. What can we do?
So that's like, because you have a diagnosis, so you know what it is. So at a certain point, you're going to have to sit down and talk to that employee about potentially some sort of accommodation as an option. With migraines, it's more difficult because they're hit and miss. But it is a fact, from what I understand it from medical professionals I've worked with in the past on this issue, with migraines, they typically happen sometimes on certain days, in certain areas. So a lot of times people will have pressure points. A lot of people will have migraines on Monday mornings, as it was explained to me, because they get worried about, pressures about work on the Sunday night. So sometimes you might want to say, okay, we're going to start our day later in the Monday morning. So if you do have a migraine, you have some time to recover, come back later in the day, what have you. But that's what you're looking at. You don't need it. You don't necessarily need a functional abilities form at that point because you have a diagnosis. But work with the employee and work with the doctor. It is a valid medical reason for which you have to accommodate.
Especially, sorry, didn't mean to cut you off.
I spoke.
This is a good one. Can an employer terminate a pregnant employee who's on probation, so within the first 3 months, because of a performance issue?
You can. I wouldn't. Like honestly, like straight up, it's like, you just gotta like there's things that there's things that you can do, like, and to say that a performance issue in the first 3 months, like you wouldn't be able to point to the performance issue because you couldn't possibly say you worked out the performance issue in a 3 month period. You couldn't, and it would almost have to be egregious. They haven't even learned how to do the job yet necessarily. So yeah, like if you have the Human Rights Code, ESA, ESC, because it's a protected leave and it's covered under a protected class under the Human Rights Code, you would have to definitively prove, because the probationary period doesn't exist anymore. I said earlier, you can fire anybody not for cause as long as you don't violate their human rights. Here's that case where you'd be violating the human rights. You'd have to definitively prove the reason why you terminated them and that it had nothing to do with the fact that they told you they were pregnant. That's not an easy hill to climb and put your pole in. Just saying.
Okay, I'm gonna try and wrap this up in 4 minutes, 3:20, just because we're way over time. I apologize if I don't get to all the questions. Can employees who sign a new contract every year, can you put them through a probationary period each time? But that would be a contract worker, would not?
If it's a brand, like, keep this in mind, if you're doing a contract concurrent year over year, if you're in the same position, they're a full-time employee, they're a permanent employee. Just so you know, just in case you're wondering, if it's different jobs, that's different. But once you bring back somebody, like once you renew the same contract more than a couple of times in a year, that's the Ministry of Labor, Service Canada, or Revenue Canada, et cetera, they're all going to consider that as a concurrent. They're going to consider that a permanent employee, and anything, and if you didn't pay them termination pay to the first contract where they started, they're going to say this whole year after year contract, which a lot of employers do, was purposely to evade your termination obligations under the ESA or ESC. So that's an employee at this point. So there's no more probation periods.
Okay, here's a good question. It's a long one. I'm going to try and do it really short. You have an employee, you promoted them into a leadership role, but they stink and no one likes them, and they're a bad leader. What can you do? Can you bring them back to their old job? You've been trying to coach them, but they're just not getting it and they're not going to get it. What can you do?
You can try. So it all depends on what the offer was when you put them in the new position. So typically this is a perfect example. And I wrote this clause for a client yesterday. The previous question about probation period, this is a perfect example where you use a probationary period. You give someone a different job, or you give somebody a promotion and say there's going to be a 3 or 6 months, and I like the 6 months for a promotion. There's going to be a 6-month trial period, in which period the employer and employee will decide whether this is a good fit or not. At any point within that 3 to 6 months, the employer reserves the right to remove you from that position and put you back into your previous job. If they did something like that, they're fine. If they didn't, they might, and the employee refuses, you're looking at a termination.
This is a tough one. We have an employee with cancer who's been too sick to work for the past 2 years. Is it appropriate to ask for a functionality assessment form, a functionability assessment form? If they come back and says he should no longer work, but he refuses to go on leave or resign, what should we do?
Well, it is appropriate to ask for the FAF, and that's sad, right? It's sad, but you're still running a business, and it's not inappropriate. Like, as much as it sounds, why would you ask a guy with cancer for? There's nothing inappropriate about that, right? You're just asking for medical. So, and you're getting the things that you need to know about whether this person can come back to work or not. If a medical doctor comes back and says this person isn't coming back to work, then you can look at the frustration. I mentioned it in the presentation. I said we're not going to talk about it. Now we're going to talk about it. You can look at the frustration of contract, and basically that's where one person is unable to fulfill their end of the contract through no means of their own, typically for medical reasons, and there's no foreseeable future to when they can come back. It's just a separation of employment. No money is owed, but you need that confirmation that they're not coming back from a doctor.
So Darcy, what about when they are they have a disability? You do the functional ability form to provide accommodation. You give them a different job. Can you pay them less money?
Not if it's a temporary accommodation. Okay. Because the idea is they're going to be working themselves. Now, you can give them a part-time accommodation and pay them less money. But if they're working the same amount of hours, then it's an accommodation. It's something where if it's temporary accommodation, they're working way back, so they get paid the same. If it's part-time accommodation, then you pay them proportionally of the same wage. If it's a long-term disability and you give them a new job, like a permanent accommodation, different story. whole nother webinar, crazy complicated subject.
Okay, human rights code, that a case can be brought forward within 2 years of the end of employment. So like after 2 years, they can't bring an employee can't bring a case forward to the human rights.
Yeah, with ESA and ESC, I know that's the case. And with human rights, I'm pretty sure it's the same statute of limitations.
Can the employer change the title and job description without change in pay with employees' consent? Well, I would assume yes, if they consent.
Yeah, whenever there's something that's consensual, then it's like, in order for it to be considered constructive dismissal, it has to be unilateral. That's the first thing. So if it's consensual, you're good there.
Is there less liability if you hire a contractor compared to a full-time employee?
If they're an FACTA contractor, but if they're working for you 40 hours a week, they're likely not a contractor. So sorry, that's a great webinar. We should do that one.
It would be totally awesome to receive Darcy's functional abilities form after the session. So that is available because we've had that question before.
Yeah, 100%.
So just email us, Erica, and we'll send it to you. Okay, we're almost done. I know I lied. It's 3:21. 87 people still. Can you change your company policy from hybrid to on-site?
That would be a meaningful term of employment. So you would require giving working notice, consideration. There's a lot there. To be honest, that's one of the biggest issues we have right now in the way of questions and dilemmas, is people trying to get people back to work, let alone changing it all entirely. So yeah, it could potentially be a costly issue for you, but it's doable.
Okay, employee car accident outside of work. They've offered accommodation, part-time, etc., but they have not heard from them since May 25th. What do you do?
It's the job abandonment process. Like, honestly, don't ever assume resignation. Don't ever just terminate. Go through the job abandonment process. It's 3 registered letters. It'll save you a ton of money in the end.
Okay. We had an employee that was missing a lot of work since the beginning of August. We have given them a short day to work, but still missing work. We have said he should go on medical leave until he can get his health issues. He has told us that he does not want to do that. So what happens if an employee says they have health issues, but don't want to seek medical help and get the medical note? And, what can you do as an employer?
Yeah, that's a challenging one, because, you're doing all the right things and you've taken it to the point where, you can't terminate. And it's possible the employee might be looking for that, might be looking for the package on the way out. But in a case like that, you're going to sit down with the employee and say, listen, here's the deal. With the amount of work you're missing, you cannot do the bona fide occupational requirements of the job, which actually require you to be here. So as such, we're not terminating you. The accommodation stands, but, your job stands, but we have to put you on medical EI.
Last question. And it's a layoff question, but we'll do it. Remember, we're doing layoffs. I believe it's in December.
Yeah,
yeah. So going back to your answer regarding layoffs, what is the correct way to structure a contract and the layoff in positions that are explicitly seasonal? In some cases, we may want them back. We may not want them back.
Right. So that's actually a really good question, because it brings up a salient point, which we talk about in the webinar in December. Is there's 2 ways you can't there's only 2 ways you can actually lay off an employee. One, it must be in the employment contract saying that you have the right to lay off an employee. If it's not in the employment contract, just because it's in the ESA or the ESC, that's only the process for laying them off. That doesn't give you the right to lay them off. So you must have it in the employment contract. Or the second thing is, you're a seasonal employer and it ought to be reasonably known by the employee that they're going to get laid off. But really, for a seasonal employer, it's even more smarter for them to put in the employment contract, we are going to be laying you off. We have the right to lay you off. And then you do not have to provide, you should provide notice. It's the right thing to do, but you do not have to provide notice of the layoff. But let's say they're less than a year employee. If you provide a week's notice of the layoff, that could serve as working notice. So at the end of 13 weeks, if you're not bringing them back, they've had that week's working notice. But so you don't have to pay them a week in lieu of notice. But if you know you're not going to bring them back, you terminate them. If you're not, provide a week or 2 of working notice of the layoff, call it working notice of the layoff / termination, and you're fine.
Yeah, I lied. One more question came in. The job used to be in office. It went remote during COVID. They want to bring them back full time. How do you do that?
If they had something in their employment agreement or had a working from home policy that states they had the right to bring them back, and I was on these webinars every month preaching that for like 2 years to get this in place. If you had that, if you were lucky enough to get to one of those webinars and took advantage, then you're fine. If not, because you've left them at home so far, if you did it right after the pandemic was over and people, the restrictions dropped and people were safe to come back to work and all that kind of stuff, you would have been fine because there's a reasonableness to the causality of bringing them back. But because we've been removed from the pandemic being over for a couple of years, that's become potentially a condition of employment. So you're going to have to bring them notice and do all that kind of jazz again. So give them 8 weeks, 12 weeks notice, whatever it's going to be, get them back to work.
Excellent. Well, Darcy, thank you very much for answering all those questions. That was literally an hour and 10 minutes of nonstop Q&A that the average human being would have taken 3 hours to answer. So quickly, and there's more questions coming in. We have to end it. We will try to get to them. Remember, in 2 weeks, we are doing an Ask Me Anything legal webinar. 2 weeks after that, the same thing. There's no presentation. We have 2 of our employment lawyers. We're using 3 of them over those 2 webinars. You can ask as many legal questions as you want for free. And if you want to have a 15-minute free consultation with one of our lawyers at HRC Law, you will be getting an email after this with that. We still have 76 people on here. We hit 144 on a Friday, which proves my theory that people do like webinars on Fridays. Nice one here. There was also lots of comments that Darcy was great and yada, yada, yada. So I won't get into that. But thanks again, Darcy. It was great. And again, hope everyone learned some stuff. We're really having fun with the doing lots of Q&As in the webinars. Anything else to add, Darcy?
No, thank you everybody for coming, and Brett, Sony, for the great job you do. Thanks a lot. Really, it's always fun working with you guys.
Have a great weekend, everyone. See you later.
Take care.